for the government to take action regarding equal opportunity in this country. The Nashville movement, again, started in 1960. Dr. James Lawson led nonviolent workshops in the basement of the First Baptist Church, Capitol Hill, whose pastor was Reverend Kelly Miller Smith, Sr. Students from Tennessee, which was Tennessee A&I at the time, Fisk, Meharry, and American Baptist Theological Seminary prepared for demonstrations by training in the basement of the church. Many of these students were arrested, but the whole notion of this movement and the design was to make sure that there were students behind that. So when one group were arrested, another group of students would take their places on the stools. And at some point, the students hoped to fill up the jails, which they did. And then ultimately, the police released all the students. In 1960, Dr. Vivian Henderson, an economics professor at Fisk, developed the Don't Buy Downtown strategy to impact the segregated businesses in downtown Nashville. Rallying the whole community to boycott the downtown stores, protesters denied a significant amount of revenue from the African American purchasing power. Z. Alexander Luby, an attorney in Nashville, was responsible for assisting in this movement and bailing many of the individuals out of jail and serving as their legal counsel. After someone bombed his house, there was a silent march in downtown Nashville, and the protesters marched to the courthouse steps to confront then Mayor Ben West about the violence. Diane Nash received word that the mayor would use his office to end racial segregation. Most businesses eager to receive business again and end the segregation in downtown Nashville did just that. The protest movement spread from Nashville across the country to Memphis, Jackson, Chattanooga, Knoxville, and other parts of the country. The legacy of the Nashville movement was that many of the leaders, Bernard Lafayette, James Lawson, John Lewis, Diane Nash, and many others went on to take prominent roles at the national level, and many served as lieutenants to Dr. Martin Luther King, Jr. and the SCLC. During this time, there was also a movement afoot in the state of Tennessee to develop a Human Rights Commission in Tennessee. Governor Frank Clements was regarded as a moderate on civil rights, and in 1963, approached by a number of individuals, and especially the Tennessee Council on Human Relations, set about to put in place a Tennessee Human Rights Commission at that point in time. On September the 30th, 1963, Governor Clements signed Executive Order 18, creating the Tennessee Human Rights Human Relations Commission. The commission's role was to encourage, promote, and develop fair and equal treatment and opportunity for all persons, regardless of race, color, creed, or national origin. The commission was to cooperate with community organizations, local government agencies, and conduct research projects to improve race relations in Tennessee. The original role of the commissioners and the commission was to organize the commission to hear about human relations climate in the 4 largest cities and to meet with the Tennessee Council on Human Relations. As the Tennessee Human Relations Council began its movement and began to meet, they also noted that there were other things that needed to be done, and there were other things happening at the same time across the country and nationally. The Equal Pay Act was passed in 1963. Title VI of the Civil Rights Act was passed in 1964. The Voting Rights Act of 1965 was passed. The Age Discrimination in Employment Act of 1967 was passed, and the Fair Housing Act of 1968 was passed. All of this was national legislation. Tennessee had a parallel course, and in 1965, the Tennessee State Legislature forbids discrimination and segregation in state-supported institutions. And in 1967, the legislature authorized the development of an independent state agency. The name of the agency was the Tennessee Commission on Human Development, which is the agency that had previously been known as the Tennessee Human Relations Commission. In 1968, the state of Tennessee officially becomes an equal opportunity employer. The Tennessee Human Rights Act was eventually passed in 1978, and what it did was it transformed the commission from an advisory body to an enforcement body. One of our current commissioners, who was also a commissioner then, is Jocelyn Dan Wurzburg, a Memphian, who wrote the law and conferred with Senator Avon Williams, who sponsored the law in the Tennessee General Assembly. The Tennessee Human Rights Act was amended in 1979 to include sex discrimination. In 1980, it was amended to include disability. And in 1983, the Commission's name was officially changed to the Tennessee Human Rights Commission. The Tennessee Human Rights Act was amended in 1984 to include housing. The Tennessee Human Rights Commission has partnerships with a number of federal agencies, and in 1987, the THRC entered into an agreement with the Equal Employment Opportunity Commission and was certified as a fair employment practices agency. It gave the commission the authority to dual process cases and provided administrative support to the agency. In 1989, the Maternity Leave Act is transferred to the Tennessee Human Rights Act. And in 1988, the jurisdiction expands to include private employers. 1988, the upper age limits of 70 are deleted from the Tennessee Human Rights, so age discrimination covers anyone over 40. The Tennessee Human Rights Act is amended once again to include familial status and disability in housing in 1990. And in 2009, the Tennessee Human Rights Commission was given the authority to coordinate compliance for Title VI for all executive branch departments and agencies who receive federal financial assistance. Our mission is to safeguard individuals from discrimination through enforcement and education. Our primary activities include the receipt, investigation, mediation, and when necessary, litigation of allegations of discrimination in housing, employment, and public accommodation. We also ensure compliance of all state agencies with Title VI of the Civil Rights Act of 1964. We provide education and outreach to individuals, housing providers, and employers about their rights and responsibilities under the Tennessee Human Rights Act. In 2012, from July 2012 through June 30th, 2013, you will see that we have received close to 11,000 phone calls. We have processed a little over 1,100 inquiries, and we filed 618 complaints. We have determined that reasonable cause existed in 4 cases and are pursuing those through an administrative hearing process. We recovered $677,500 in monetary benefits through mediation, settlements, and conciliations. Throughout this year, we had 45 Title VI file complaints, and we reviewed the implementation plans of 42 agencies. We conducted 122 outreach activities, and we sent out 1,700 plus complaint forms. And this is an overview. To get more information about our accomplishment and issues relative to the Tennessee Human Rights Commission, you can always go to our website at www.tennessee.gov/humanrights. We are governed by a 15-member board of commissioners made up of Tennesseans who represent employers, business owners, religious groups, trade unions, human rights groups, and general public. As you can see on the screen, Five of individuals are appointed from each of the grand divisions, and they are listed. Our chair is Stacy Garrett, who is in Middle Tennessee. At this point, I've been pleased to discuss this with you. If you have any questions, please let us know about our history and that. I am pleased to turn the program over to our Deputy Director, Sabrina Hooper, who will provide you an overview of our laws and how we process complaints.
Good afternoon. The state laws we enforce are the Tennessee Human Rights Act and the Tennessee Disability Act. Both of those laws are the substantial equivalent to the federal laws listed here. As was stated earlier, we do have a partnership with the Equal Employment Opportunities Commission and the U.S. Housing and Urban Development. With those partnerships, we are able to dual file cases in employment if they have 15 or more employees, and in housing if they have 4 or more. We are able to dual file those cases in order to avoid duplication of efforts in investigation. As you heard earlier, in 2009, we received the responsibility of the Title VI program. What that does is it allows the Commission to verify that governmental entities who receive federal financial assistance, they must comply and must not discriminate in programs, benefits, or activities based on race, color, and national origin. We have the authority to set guidelines and have agencies comply with those guidelines every year. Within our laws, we have protected classes. Our law covers housing, employment, public accommodation, and Title VI. Housing has race, color, national origin, religion, creed, familial status, sex, and disability. Employment covers race, color, national origin, religion, creed, sex, age, and disability. Reasonable accommodations in employment are referred to the EEOC. Public accommodations has race, color, national origin, religion, creed, and sex. Any disability in that area, we refer that to the Department of Justice. And again, Title VI does race, color, and national origin. The protected classes slide, there's a glossary of terms for anything for further explanation. I'll pick out a couple here. Color is when within the same race that there's a skin pigmentation either lighter or darker than someone else's. Another one you may not be familiar with is creed. Related to the religion, it's a system of religious beliefs, and it really came about before we had organized religions. In the age category, you have to be 40 or older and have 20 or more employees. Also, there's retaliation, and that comes about if you felt an action was taken against you because you've complained based on these protected classes. There are 4 elements that our intake staff reviews with every inquiry we receive, and this is called establishing jurisdiction. State employees must have 8 or more employees. They only need 1 for retaliation. Now, satisfying these elements does not mean discrimination occurred, but it allows us to investigate to see if discrimination occurred. So the first thing we look for is how many employees. Allegations must also be filed within 180 days unless of the last discriminatory act, unless it's a continuing violation. The third thing we look for is that you must allege a basis, which means the action must occur. The action that occurred must be based on a protected class. And you must identify in employment an adverse employment action, which is failure to promote, failure to train, etc. Jurisdiction and housing. It has the same similar 4 elements. In housing, any dwelling in Tennessee that seeks a public transaction, either sale or rental, that's not covered under exemption. The property must be 4 or more if we're going to dual file it with HUD, but we do 1 covered under our jurisdiction. Some of the exemptions are if it's owner occupied and it has a dwelling less than 4 or more units, then they would be exempt. If it's a private club or a religious organization, they would be exempt. However, no exemption exists for discriminatory advertisement or acts of interference, coercion, or intimidation, or harassment, or retaliation. Similarly, as in employment, the allegation must be filed within 180 days of the most recent date of occurrence of the alleged discriminatory act. And again, the action must have occurred because of the protected class. The issue must be identified as well here. It can be a refusal to sell, rent, negotiate, even in financing or advertisement and the like. Commission complaints. In 2012-13, our complaints in housing, we had 100 cases, and the highest basis that we received was disability with 46% and race at 36%. Some things that we may see in disability is a tenant requests a reasonable modification like a ramp to assist with the enjoyment of the property. The landlord either denies or unreasonably delays the request. That can be something that we can investigate. In race, it may look a black couple calls an apartment complex that has advertised for rent, but when the couple arrives to fill out applications, the apartment is no longer available. In employment, our 2 highest is again disability and race. And sex is right up there at 18%. Race, we see lots of occasions of failure to hire, failure to promote. In sex, there's sexual harassment by coworkers or even supervisors. So let's look at the complaint process. What does it take for us to get a complaint to process through our organization? First, the complaint must be filed. It must have the original signature. In 2012-2013 fiscal year, the Commission received over 1,000 forms that we had to review, and we have 2 employees that review all intake. Once they review it, they go through those 4 elements that we discussed earlier. It must have an original signature, and it must be received within 180 days of the alleged discrimination. Once we establish that we have jurisdiction, then we send notification to the respondent. The respondent has 20 days in which to respond to the allegations in writing. We do not investigate anonymous complaints. They will also have an additional 14 days if, upon request, if they have obtained an attorney and they need extra time. Within the first 45 days, we always offer mediation. Within the Commission, we have 10 Rule 31 certified mediators. This year, we closed 37 mediations, and we received close to $500,000 in benefits to the complainant. Both parties must agree to mediation. If they mediate and it's resolved, then the case is closed. If they mediate and it goes to an impasse or there's a disagreement, then that mediation is assigned to a different investigator. None of that information goes over to the new investigator. They must start fresh. In housing, there's a process called conciliation. We ask that our investigators offer conciliation at least 3 times throughout the investigative process. The investigator conveys offers and counteroffers between the parties. Last year, we had 49 conciliations, which we received close to 90,000 monetary benefits to the complainant. If it's successful, then we close the case. If it's unsuccessful, the case is continued investigation until we make a determination. While the case is in investigation, investigators interview complainants, respondents, relevant witnesses, they request documents, they conduct rebuttal interviews, and they verify defenses, and sometimes we have to go on-site when necessary. Housing closed 107 cases last year, and employment closed 451. All through the case investigation, a settlement process can occur as well. Both parties can talk and agree, and if they agree to a settlement, we have a legal team that reviews all contracts, all settlements, all agreements to make sure it's legally sound. In employment, we had 24 settlements for close to $125,000 benefits to the complainant. If a case does not settle or go through mediation and must go through complete investigation, then the commission must issue a determination. There's 2 ways to do that. We can have no reasonable cause of discrimination was found. Even in that, the complainant has 3 more options. They'll receive a letter that is signed with that determination on it. They can ask for a reconsideration. During the reconsideration process, whichever legal team reviewed that will go to the opposite legal team for the reconsideration. You have 30 days in which to request a reconsideration or an appeal. The second option is you can appeal to state court, or you can file in federal court if the case was dual filed and the federal laws are applicable. The second option is we find that reasonable cause for discrimination occurred. Again, after that, there's an opportunity to conciliate or have mediation. If that fails, then the commission has an administrative hearing that it goes to. Once it goes to administrative hearing, all documents are public, and the administrative law judge will provide a final order. And then there's always another appeal process after that. So you have heard the complaint process. Here's some upcoming events. The upcoming events for the rest of the commission: on December 10th, 2013, in Nashville, Tennessee, Sunny West Conference Center, we'll be celebrating Tennessee's celebration of International Human Rights Day. The commission will also be having hearings in Memphis on January the 28th at Rhodes College. We'll have a hearing, and these hearings will have entities from across the state be able to come and provide what's going on now in their institutions about human rights discrimination. We'll have one in Knoxville on March 25th, Johnson City sometime in March. That date is to be announced. And also we'll have another fair housing webinar in April. And a national status of human rights hearing will be in May. Please watch our website for those dates to be announced.
And we're listing some resources for you. Of course, I've given you our website, the Tennessee Human Rights Commission, www.tennessee.gov/human rights. Will give you not only the resources but other information. Upcoming events are listed there. You can always go to HUD.gov or EEOC.gov at the federal level. And three others are the Leadership Conference, www.civilrights.org, Columbia Law School, Civil Rights Institute, and the Tennessee for Me History. Are there any questions about anything we've talked about today or about the Commission in general?
If you have questions, please use the chat function.
We've also given you our contact information, so if you have questions after today's event, please feel free to call us at our 1-800 number, 251-3589, or you can contact us through email at afo4.web.contacts@tennessee.gov. Thank you for participating today. We look forward to doing more webinars in the future. If you would like a particular topic, also please email us that and provide us with information about your experience today. Thank you so much. We will talk with you soon.